Yay! I am so excited to introduce to you Martha Broadway. I'm going to say all her credentials, but overall, she's an amazing lady. She just really is. Um, she's licensed in the state of Maine and the federal courts since 1983. She's experienced in bankruptcy, business, legal issues, family law, and estate law. And she serves the community directly through legal representation, workshops, and training. Her business is available for legal services for the elderly, AARP, and the Penobscot Bar Association clinics, and her private office serves a select group of clients for personal and business issues, and they are a full-service office that does not discriminate. So I'm super excited to introduce to you ladies, Martha Broderick. Here she is.
Thank you. That's just very kind. I am very delighted that Robin contacted me. As I told her, this is a community service that I think is very, very important, especially for self-employed individuals who are making it go in the world, but also for all parents and families and people that are single and people that are in relationships, because comes a point in all of our lives where we're not necessarily going to be able to communicate the way we do now. And there may come a point in our lives where financially we may be confused. And there may be a point in our lives too where we all will get, and that is the foot of the bridge. And when we get to the foot of the bridge, we want things to go the way we would like them to go. And this conversation is difficult. It's difficult to have with your spouse. It's difficult to have with loved ones. It's even more difficult, though, for them when you can't communicate. So I like to encourage everyone to consider the scenarios of what can and can't happen. So if it's okay with everyone, I'm going to move into a screen share. Hopefully everyone can see what I've got up here. And so, I need the host to allow me to screen share, whoever the host is. Who is the host? Okay, good. If you could just allow me to screen share, that would be great.
Let me see.
Yeah, at the bottom, you'll say screen share, and you just have to say allow.
Oh, there we go.
Yeah. You got it? Let's see if he'll do it now. Nope, still disabled.
Nope. So I'm sorry for the confusion. You're asking it should pop up for me and say?
In order to share my screen, you have to allow me to do that.
If you click on participants, Laura,
Yep.
And then you'll get the list of participants up on the right, and then you'll click on Martha's profile, and you should get an option for more, and then you can promote her to a host, or there's probably just an option to allow a screen share as well.
Let's see. I'm just going to make co-host, and there we go.
Okay, thank you. Thank you. That should solve the issue. Thank you so much. Okay. And as soon as we get to this, and it's not quite there yet, still coming up. Hold on a minute. I have to get my mind to work now. So hold on a minute. It's nothing like a little bit of technology to teach us all what we don't know.
Okay. I'll relate, Martha.
Okay. Okay, hold on. I have to say okay too. Okay. Everybody's got an okay. Yes, you can. Yes, yes. I've got a firewall out. Of course, I tried my new computer today just to make life easier. So hang on, there it is. That's my screen. There we go. Allow. Yes, 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 yes. Okay, so that should do it. And that should allow it. All right, let's try one more time here. I come back to you. Yeah. Okay. And where's my Zoom? All right, we're gonna try one more time. See if it lets me now. Oh, it's still not letting me. I'm sorry. Hang on just a minute. Let me see why it's not letting me. So let me on my own screen. Come on, guys. Where are you? Oh, okay. Hold on. I have to somehow share a different way. I'm so sorry. I thought I had this all working. My apologies. Just one second.
You're absolutely fine. You take your time.
Yeah, okay, it's just a.
I was gonna say, take your time. It wouldn't be Tuesday Forum if we didn't have computer issues, right? And connection issues.
Oh,
That's just how we roll here.
But you're so kind. I did not switch to I switched to my fancy computer, which is not always the best thing to do on an opening day.
Oh, don't worry, please don't.
Yeah, do not worry at all. Yeah, it's,
If only she had seen us last week, right, ladies?
yeah, pretty much.
Okay, firewalls.
Yeah,
Yeah, we're all trying to learn to reduce stress.
Yes, oh, there it is. Okay, there's the, okay.
This is probably a good
Okay,
time
that's
if folks want to
okay.
add their contact info into the chat, just for other folks to reference.
Good idea, Laura.
Yeah, oh, that'd be great if you could do that, then I'll get to see that as well. Oh, there it is. Yay. Okay, we're happy now. It's gonna happen. Here we go. Okay, all right, good. All right, I'm gonna shrink down some of this and put this where you can all see it better. And there, all right. So you should be looking at my screen at this point. If everybody just give me a thumbs up so I know you are in fact looking at my screen. That's awesome. This guide is available to you. I printed it out years ago to kind of give you a walkthrough of what the process is going to look like for anybody in your family that has to deal with you in a difficult time, or if you have to deal with others during the time of their illness or passing. What we are always concerned about in any time of our life is we may become incapacitated. At that point, especially if we're running businesses and families and have a busy life, someone else has to step up and help us run our business and our families. Normally, you might have a spouse or a child or a friend that knows what's going on, but unless they have the paperwork to go with it, they're not going to be able to do what you think they should be able to do. So let's take a look at what the process looks like. First of all, there's a lot of terminology involving estates. These are basic in the sense that we use old language because it's an old law. It's been with the state of Maine for over 400 years. We've just recently redone the Uniform Probate Code in 2018 and upgraded a lot of the forms to a more modern approach, but it all is basically the same. Who is going to help run your issues? Who's going to help you if you're still with us but need help? That would be a guardian or conservator. And how are they going to do all this? Are they going to be able to do it just by saying, I get to, or do they have to have some documents that help them? When you're still with us, and there are two major documents that need to be looked at. One, you've already probably done at the doctor's office, the Advanced Healthcare Directive, also known as the Living Will. Those documents give some indication of who you want by your bedside to help make decisions when you're incapacitated, but they also give some end-of-life decision-making that you may want to do. Those are important for you to make that known as to if you want a natural passing or if you want medical intervention right to the end. There's also an ability to state your funeral wishes, also other issues with regards to organ donation, and if you have a favorite physician who might coordinate your care. Now, the next one, the more important one before we get into the actual real estate and the estate issues, is the financial power of attorney. Lots of women skip this state because they're not running businesses or they're not handling the money. I think that's a terrible mistake. I think there are many, many times where you might become confused, or you might end up, even with having a teeth extraction, to have a few weeks where you can't really understand or read things. My own example is I was in a car crash and I was 30 years old and I had a concussion and I couldn't read. Can you imagine that? An attorney who can't read? And I couldn't sign or read anything, and I needed somebody immediately to take over cases and do certain activities. And I had not done a power of attorney. And so at that moment in time, we all had to depend on the courts to give us a temporary guardianship so that they could read and sign things for me, since I could not read or sign anything. And I thought I understood everything people were telling me. But I've heard some tales since then that I got a little confused. When you're looking out from an injured brain, it doesn't look like you have a problem, but you do. And it took about 3 weeks before I could read again. And by the time I could read and come back, the guardianship ended and I was able to move forward. Had I had a financial power of attorney, that person could have executed and done everything they needed to do without the court's involvement. So again, strongly, I recommend the Advanced Healthcare Directive, also known as the Living Will, and the power of attorney, especially a durable power of attorney, which will go past any incapacity that you may have while you're still living. Now, with the end of life comes these decisions as to where things will go, how you'll be buried, and what activities you want at those funerals or other activities you may want. A will is where we created in many decades and many centuries, actually, to give direction to family members and to the court legally as to what you want and desire. This is especially true if you own real estate in your own name or a business in your own name. If you have a partner or you have a husband or spouse, they're very important, but they no longer get the status of next of kin, which means they're in charge of everything. We changed all that in the late 1990s, and even they have to be appointed as personal representatives. It's very important that you take the time to create that will that states first who your family is, who are your children, who are your spouse, and that helps with any confusion. You also might have somebody that is no longer important in your life or is no longer wanting to be part of your life, or you don't want them part of your life. And in this state, we don't call it disinheriting, but we do call it an intentional act to leave them out. And that has to be stated also in the will. Then we choose who we want. Normally, a mutual will pick partners. So your partner will be your mutual will, and their will reflect that you're their partner as well. And those people, spouses, domestic partners, and others, will step forward and take that will to the courthouse. Now, this is the process by which the court will follow that through. And again, as you look at it and think about it, it's a pretty straightforward process. The original death certificate, the original will have to go directly to the courthouse. That's even if you're not the personal representative, so that the court now possesses that and it can't be altered or no tricky stuff. No, using the copy machine to change who the inheritance goes to. It usually is filed as early as, again, 4 to 5 days as soon as the death certificate arrives, but it can be as long as 2 years before people file into probate. People often ask me, when do I have to go to probate court? Whenever there are any assets standing in your name alone. And that means especially, again, real estate, bank accounts, and other sorts of assets. The way to get around probate, if you don't want to go through the waiting period, which we're going to talk about in a few minutes, is to create yourself an estate before you die that's a lot like the estate you had when you were born. Everything gone. So you put everything in someone else's name in the sense that you add people to your deed as joint tenants or as tenants in common. You make sure that your bank accounts, life insurances, retirement funds, IRAs, all have named beneficiaries. Then those items will all pass outside of the estate, and the estate itself will be insolvent. There'll be nothing left in the bowl that we call our belongings because you've already made other people your joint owners. If you skip that step, or you forget, or if you die in a tragic accident that has to be brought to court to see who was responsible for your passing, then we need that will. And the will name the person who will carry forward your business until it's concluded. The way it works is once the filing happens, once there is, again, a named representative in a will, and if there is no named representative because there is no will, they will follow a process known as intestate probate, which will go to your next of kin. And that gets sloppy and messy and stirs up all kinds of unkind feelings sometimes. Sometimes there is lingering resentment. Sometimes there's just misunderstandings that suddenly arise, and we end up having children fighting each other or brothers and sisters fighting each other, and we just don't want that. At this point of a tragedy of someone passing, we want peace, calm. We want to not have the family in a riot. So again, the will manages that for you. Once the will is filed, the court will issue a letter of authority based on the will if there is one. Without one, there'll probably be a court hearing to determine who will be the personal representative. There then, and as you see down further here, notices that go out to everyone. Anyone who is related to the person who passes gets notice of that. The people who are heirs have seniority or priority in the probate process. The inventory of the estate is taken by the personal representative. That's basically a simple list of everything worth more than $50 that the person owned alone. If they owned it jointly, the joint owner now owns it 100%. So in a marriage, for instance, it's all marital property. The remaining spouse owns everything. Real estate, I hopefully as well, if they have joint tenancy on their deeds. And I just had a deed situation come up from 1983. 3 parcels where a party got married, they put into the names of their new spouse. On 2 of the 3 deeds, it says joint tenancy. On 1, it does not, which means when the first spouse passed, 50% of that real estate remained in their estate and nobody realized it for 42 years. Now we have a problem. We have to straighten out the title, and it's going to take a little extra work and deeds and everything else, and they can't sell it tomorrow because they don't have clear title. So again, the inventory of the estate looks for these errors. They look for everything to be in joint ownership or not, and if it's not, it's part of the estate. Then comes the claims period. The claims period varies, but in the state of Maine, the maximum amount of time they have is 9 months. Preferably, it's going to be 6 months because you will have the estate itself published in the newspaper. A notice, you've seen these, and the notice will basically say, we ended up having, so-and-so passed away. You have 4 months to file a notice of claim with the estate. You also, as business people, may decide you want to claim against someone's estate a bill they owe you. A notice of claim is the document we file with the probate court that alerts the estate that a bill is due. They can debate that with you. They can ask for a hearing on that. They can decline to pay it because the estate is insolvent, or they can call you and say how much is due and ask to finish paying it off. I have found most families who have the wherewithal to pay off the bills of the decedent as long as they know about them. And they may not know unless you file that notice of claim. Once the claims period is over, we balance up the books. The way we do that is there are priorities as to who gets paid first, second, and third. Anybody being supported by the decedent, dependents, have special homestead and dependent status, which means they'll get some of the original first cut in the apple, so to speak. After they're taken care of, then we move into final expenses such as funeral bills, last medical bills, and the cost of probating or taking care of the estate. Once those things are done, then we move into secured creditors, and from secured creditors, then we move into unsecured creditors, much like a bankruptcy perhaps would do. At the final end, when all the bills are paid, then we're going to distribute the remaining assets to the beneficiaries. One question, it's always really a great question to ask is, well, I want to give my house to my children. How do I avoid any bills attaching to the house? Well, that's not an easy answer. Basically, keep your bills paid is always my answer to that. You can't protect an asset from the IRS or from Maine Care. If it exists, it exists. And if it exists the day you die, it will be used to pay those bills first. Again, the funeral bills, the last medical bills, and the administration costs. The last medical bills can include long stays in nursing homes if necessary. And that's where, again, Maine Care sometimes comes in, but sometimes it's been private pay. And people have been paying right along, or their insurance is paid. And those bills are not as large as you think. People often ask me, how do I save money on my funeral bills? Well, prepay them. My idea of that is go get a mortuary trust where you can actually plan, or mortuary plan at a funeral home, and you don't have to pay any money at all to do this. And you create the plan. Maybe you prefer to be buried next to your spouse or parent. You know exactly where, you know what type of casket you want, you know if you want to be cremated. All those things can be done in writing through a mortuary plan or in your will or in your advanced healthcare directive. These are important to everyone, and everyone has a different point of view as to how that should happen. It's very important that the person you pick to carry through your wishes agrees. One of my first cases, again, at a young age, I was about 32, in came a spouse with a will that clearly stated that the other spouse wanted to be cremated. They were religiously against that decision. And it was very difficult. The family was very upset and distraught that she wanted to be cremated. The court upheld that stated directive and instructed and ordered the estate to cremate the body. Now that disturbed the spouse something terrible. What I would suggest that if you are going to have somebody do this for you, that they know your wishes. And if they cannot or do not want to go through with that, that you pick someone else for at least that part of the arrangements that need to be made. There's also, again, sometimes a situation where the body has to be autopsied because someone dies alone. That is a law in the state of Maine. If they die alone, it's going to be required. The reasoning, again, is that we want to be sure that there is no mischief afoot, that they weren't poisoned accidentally by carbon monoxide. We're trying very hard to make sure that that's not an intrusion into the family, but it is required. There's also people who choose to donate their bodies to science. If they do that, the receiving institution will oftentimes do what they need to do with the research end of it and then return the ashes themselves paid for, and they take care of the cost of cremation. So there are lots of ways to take care of our remains, but if you have a specific idea, get it in writing so that the rest of the family knows and that no one does something different that might, again, disturb your rest. One of the other reasons that we ask people to talk about their decisions is that we want to reduce family fighting over litigation over probate. That's very expensive, and all the cost of litigation for probate comes out of the estate, which means there's nothing for anyone if we all fight too long. So again, if you've decided that one of your children is in more need than another, or a friend is who you're going to leave your estate to, you don't have to tell everybody, but you should definitely tell the person who you've made that final decision as you decide that they should be sure to know of your probate. You might also tell children especially that you have made a different decision than regular and that they'll find out about it sooner than later, but you're not going to argue with them, that this is your decision and that you've made it. Some people let people read their wills. I don't recommend that. And the reason for that is you can change your will anytime you want till the minute you die if you're competent. We do have people change their wills. I go to hospitals and change wills. Through COVID, I had to change quite a few wills because people were dying before their time. So there are a lot of different reasons why people at the last minute change their wills, and it's not all evil. Sometimes it's to meet the needs that they're meeting in life, that they are supporting or taking care of people already that they don't want left stranded. And the normal course would be that it would all go to their children, but this person that they're helping or dealing with or supporting, or could be a parent, it could be a friend, they want it to go that way. And that's your choice. It's always your choice. Now, sometimes there's a tax and people get very excited about this. I tell everybody, calm down. Unless you've got over $1.5 million, there's not going to be an estate tax. We do have on the state of Maine an inheritance tax that's there. It's currently at 0%. It's sitting in the background waiting in case the state of Maine suddenly ran out of money. They could suddenly raise that. In my lifetime of 35 years of practice, I've only seen it raised once, and only very temporarily when we had a tremendous budget fall in the state. We tend not to tax our estates, and that's why we have a lot of estates come here. People who have residence in the state of Maine benefit both from their trusts that we have a very strong law for, and also for the lack of a true estate tax. Now, the federal government, on the other hand, I can't vouch for. I have no idea how hard or fast they're going to come after everybody's estate after spending $1 billion. And I can tell you that oftentimes the estate tax is the hole they go to. Estate tax is usually reserved for the top 5 to 10% of the population. But in my lifetime, I have seen it come way, way down and take a lot of money. They've also made huge mistakes at the federal level. One year they forgot to put in the tax, and there was a whole year when a sports team in Florida's owner died, and his entire estate was well over $20 million. They didn't pay a dime in taxes because the federal estate law was so messed up. So I can't tell you what the federal government's going to do at the time you die, but I can tell you if you have more than $1 million at the time you die in your own name, that's more than likely to be taxable. So those being the concerns, then we usually get to the disbursement end, and then we finally close the estate, which is really fun and great. These are the forms that, again, usually are used. You'll see that these are all online at mainprobate.gov, and you can read all of these and get an updated versions of these. I think mine are just a tad old on this particular one, but they basically are the notice and the letters of authorities. These are the things the court will issue. These are the forms that everybody signs to accept being a personal representative and to nominate others to be that personal representative. For instance, if you were your spouse's personal representative, but you were in the same accident that caused them to pass and you're injured, you may well want to pass on being the PR and let someone else do the work while you recover. So there are good reasons to not be the PR if you are appointed, but not well, or not feeling good enough, or just too much in grief to handle the duties that this requires. And you can see it's quite a lot of work, actually, over a 6 to 9 month period to administer an estate. This is what the inventory looks like. People always ask me to tell me what that looks like. Well, we're going to look at the real estate, the personal property, and the bank accounts that are in their names alone. You'll notice that do not include joint tenancy language there. The main estate tax due, again, is used to clear real estate. This is, again, usually filed when we need to clear real estate that will be sold to satisfy the will. Right now, this is very simple because there's no amount of money due because there's nothing listed under that situation. So we have very basic forms. They're not hard. Everyone can look at them and follow them. If you can do your own taxes, you can start your own probate. My only concerns is ever that someone gets started and it becomes a battle. In that sense, it's a nice thing to have an attorney assist you that can talk to the rest of the family while you're in grief or while your family is in grief. It's sometimes great to have somebody that you know already or you're working with on business issues refer you to a probate attorney. I'm a probate attorney. There are several in the Bangor and other areas that are all excellent. They're peaceful people. We are not the battle axes, but we do have to go to court and we do have to litigate in the probate court and the district court at times. So having some litigation experience is a good idea because, again, sometimes we have to marshal the assets and prove the ownership and other issues, distribution issues that may arise. It's very hard to split, for instance, a diamond ring. And if the proceeds are supposed to go 5 ways, there's going to be a fight over the valuation of the ring. That takes 3 or 4 appraisals. Sometimes everybody's got their own and the court has their own. And we have to have a hearing on that because then we have to sell it in the open market, sometimes at auctions. And those big things, I would rather see in a will. I would rather have somebody have said in a will, my jewelry is to go to my 2 daughters. This one gets that ring and this one gets that earrings. I literally encourage people to go that far or to use an estate notebook where you basically get a spiral notebook, fill it up, write down where you want everything to go. And that estate notebook is referenced in your will. And then the PR has a direct thing to go to say, nope, this is what everybody's getting. You're getting this ring, you're getting that picture, you're getting that antique, and that's the way it's going to go. And then there's very little fighting. I have to tell you, my other favorite way of solving these issues with people that have multiple children is to pretend you're having a yard sale, have them all over for Thanksgiving dinner. After dinner, hand them all a color and say, stick a sticker on whatever you want. And if 2 people have the same sticker on the same item, you flip a coin. If it's 3, 4 or more, you do short straw, and that's it. That's the way it goes. And you leave the stickers on, you don't take them off. And you record later after the children all go home what they picked, and you put it in that estate notebook to now take all the argument away from any distribution of items. And you'd be surprised how that becomes a terribly difficult time. In my own family, my father and his brother never spoke again after the dispersing of his mother's estate because they fought over the clock on the mantle. And they fought so bad, they yelled and screamed so long that the rest of the brothers and sisters left the house. So I don't want anyone to go through what my family went through. And I encourage you very much to be careful and to pay attention to your own, and then your family and friends, to encourage them, especially parents that are elderly, to not let this go to chance. They'll say, oh, you guys won't fight. Say, no, we won't, especially if you make sure you tell us what you want. And again, keep coming back to that. Let people be self-directive as long as they are possible. In law, we have a different standard to incapacity than a guardianship. We have this thing called testamentary ability. As long as somebody knows their name, where they are, and the basic season they're in, can name their what they call natural objects of affection, that would be their children and their spouse or their brothers and their sisters, they can make wills, they can make power of attorneys, and they can make advanced healthcare directives. So even somebody who has early onset Alzheimer may still be able to do this activity. And I would not wait long, because once they don't know their name, once they cannot name their spouse, that's when we can no longer do a will for them or a power of attorney. And we'll have to go to court, intestate, and we'd have to go to court to get guardianships if they needed that for treatment, especially in the end stages where they might live quite a long time with some conditions that are disabling. So it's a serious job, but it's one every one of you can do. And so let me just open it up for quick questions. And again, I have my email, which I would like to give to everyone. If you'd like to email me after this, I always respond within the week. I tell people I'm a little busy right now, but it's a long one. So let me give it to you. It's Martha B, MARTHAB, at maine.edu. As many know, Lori knows, I'm a professor there. And if you put right in there Tuesday Forum in the subject matter, I'll see you pop out of my 200 students. And I will be happy to email back personal answers for any of you. But if you have a general question, I'd be happy to answer that now.
Martha, could I get you to give us your email one more time just to make sure I wrote it down right?
Sure. It's Martha B at maine.edu, and I will put that in the group chat right now.
Perfect.
There we go. There we go. And I have a much longer one, which is my office one if somebody needs an appointment. And again, it's so long that I hate to tell that to everybody, but that's the long one. But that's the direct link into my secretary if you need an office appointment. The other one will be my more general email. Okay. All right. I'll close that. Okay. All right. Other questions?
Thank you so much, Martha. That was so interesting. And I think it's really good that you're emphasizing to get these things done in advance, because no one realizes until you go through it how much a camp can fracture a family. I had an elderly dad who had more advanced Alzheimer's. We took him to an elder care attorney when he was still in the early stages so that he could definitely direct everything for his will. But I had a family member who snuck him to another attorney when he was very advanced and changed the whole will.
Right.
And it fractured our family because it was done. Everyone, everything was designated, but this one particular member did not like that he didn't keep the camp all to himself. Right. So I still am in disbelief that an attorney allowed my dad. I was at the time, I'm a registered nurse and I worked in elder care. And I was his medical power of attorney, and he had lost capacity long before that. He was much like maybe a young child and couldn't do anything. Used to think I was his wife, but they obtained his signature and he changed the will. And so it gets really nasty. So anyone who hasn't
very nasty.
Done, do it. Get it done.
I was amazed at some of the frauds I've observed. I had a gentleman who was in a stroke condition, and his a wife of very short duration managed to get a notary in and change the will when he had not been conscious for over 6 weeks. And the notary and the 2 witnesses swore to that in court, that he woke up suddenly and changed everything. And yet later, tracing it later, they found that all of them got large payments from the family for changing it. And it was the most horrendous fraud I had ever seen. But the amount of stress, money, and time that got wasted on that was amazing. So keeping things safe in the safe deposit box, a firebox in your house, in the front right, I call it, look at the house, the front right side is where the firefighters will go with a scoop and pull out whatever's there, looking for metal boxes. I didn't know anything about this, but this is really true in me. And the firefighters are all trained to do this. And they told me at a firefighter meeting I was at, tell everybody front right window, because they can reach stuff there and scoop it out. And they are more than likely to find your firebox if it's there, if your house collapses and everything burns. And we've actually done that. I've actually had 3 or 4 of those boxes recovered. And it's great. Everybody survived in all these fires, but just to know that you could actually find a box again when a house burns. So it's not a bad thing to have a little Walmart special. It doesn't have to be fancy. I don't like people to, like I said, make copies and distribute things unless necessary, but the Advanced Healthcare Directive should go, the health one, the living will, to your physicians. That is something I would have you drop off at your doctor's office while you're still healthy, so that it gets scanned and put in the medical records. Now are all electronic and are shared all over. And that, if you were brought into an emergency room, they could find it. So I tell people that's for everybody, every age. And I like every parent to have this, because in a will also you can name who you want to advocate or step forward for your children if you and your spouse pass away at the same time, which people think, oh, that never happens. Well, in my experience, I have had at least 5 to 6 in the last 10 years where they die together. And God forbid that happens. COVID really turned that number up. And we had people dying within weeks of each other. And we had minor children that we had to deal with. And luckily, almost all of them had wills, but it was, it's a horrible moment. It's a terrible time. You need immediate direction. So if you do have children who have children, or friends that have children, this is a good conversation to have, is to say, who will watch your children? Who's going to step forward? I'm never going to die. Oh, well, good for you to know the date. Most people have no clue, and it's always a surprise when your ticket gets punched. I don't think you're 99 and you expect the day. So I think that young people that are in their parenting ages absolutely need to have these documents. So that's another group that I really stress. But I like business women to think about it, to be honest. A lot of us business women are very independent, and we don't ask anybody for help, and we don't ask or look at our books the same. We just are in control, and while you're in control, you are. But who is your second in control? Who's your second in command? Get them on paperwork so that they know where you keep your books, who your tax accountant is, who your life insurance. There's a need to get this all in a binder so that it can be easily handed to the person who has to step in, especially businesses that are ongoing concerns that are doing well. There's a lot to your books, and you think it's easy because you've been doing it. You sleep with it at night, right? So it's different for a new person stepping in. I had someone who passed away, had 16 employees. We had a lot to deal with. We had a lot to keep the business going until we could sell it. We had to keep the staff on board. We needed to know about the staff. We had personnel records to protect. There was a lot of things that had to happen. Luckily, we had a tag team between 2 people that she had named. So that's succession planning for businesses. And I would suggest anyone who is concerned about their business or wants it to pass on to someone else or wants it to pay for certain items, get somebody you think about as your second in command. And that should be one of the people on your financial power of attorneys, because they're going to be the ones that are needing to sign, tax returns and payrolls and things like that. And don't be bashful about it. You could be out just for 24 hours. You could just have surgery. You don't wake up too fast from mouth surgery, and it's not terrible, but you don't wake up in time to pay the payroll. So it's the little things that catch people off guard.
So Martha, I'm sorry if I missed this. This has been incredibly helpful. You actually help people create their wills, correct?
Yes, I do.
Clients, okay, good.
I do. Yes, yes.
And do you charge a flat fee for a simple will, or do you?
I do. I do. I have an AARP special, and then I have a regular flat fee for people that are under 65. So 65, I use the AARP that's included because I believe all three of these documents need to be done at once: a will, a power of attorney, the durable power of attorney, and the advanced healthcare directive updated. And the reason, again, in 2018, we changed all of these documents, especially the durable power of attorneys, must be updated. It is going to be accepted by the banks from 2018 to now. So if it's pre-2018, you have it, it needs to be renewed now. And it basically runs $250 for all three for that. And it's a little bit more for the people under, but not a lot more. It's like $50 more. I want these done. So I tell people we keep it really flat low. And I also do clinics sometimes where if you had a group of people who wanted to do it, I do it as a clinic basic. I do all the intakes. And then after I do the intakes, I go home, draw all the documents, get my witnesses to come, and we execute them in the same way. We get everybody in and out. So I've done that before for Rotary clubs and for other groups. And that sometimes is a great thing to do, you know, after and before other presentations and events. And I think that helps. I've done it for church groups as well. Sometimes that's a big need in a church group. They talk about other issues for end of life, but they don't get their documents organized. So that's another area that I like. Again, within families, if you did come, let's say with your spouse, I would have the two of you in the same room. But if you came with your mother, I would have your mother talk to me alone. You can't be in the room and influencing other people, even if you're the person who writes all their checks and knows everything. I still would need to talk with the person who's actually making these documents without any present influence. And that's because of what happened. And you heard the example of one family already. And I think it's very important that the privacy be respected too, because, you know, we all have different values and special concerns, I call them. My dog is one of those. And, you know, my dog is going to get some money, whether my kids think so or not. So my dog is not going to get put down with me. My dog is going to live. And I already have somebody else who's going to take him unless my kids really agree to keep my dog alive. Because they made a bad joke one year at 4th of July. And my dog is my mother's dog. He's a Pekingese Pomeranian mix. He's a circus animal. And he's not what most people would consider a real dog. But, you know, my kids are not putting him down. He's outlived my mother. He's probably going to outlive me, and that dog deserves circus, you know, so we're going to take care of that. But that's the sort of thing. You might have other private issues that you want to address, and some people like to live a tie to their church. Their kids may not agree with that. Too bad, you know. Some people like to leave something to their alma mater. Some people want to leave something to St. Jude. Somebody wants to leave something to the Humane Society. Do it. That's what we call, you know, those gifts keep a lot of things moving forward in the world. And if we give everything to our kids beyond their education, we're being really generous. So, you know, spread it out a little bit if you do have wealth. And if you don't have a lot of wealth, even be more careful. Give it to those who you really want to enjoy what you have left. And it's very, you know, I have some beautiful paintings that my kids hate. Well, they're going to my friends, and I've already decided that. I'm an art person, and I've collected them for years. It's a little eclectic, but my kids are like, good, just clear the air. So those are the things we do when we plan our estates.
Martha, I have 1,000 other questions that I think are, but I won't ask them all. One is just a comical observation that the front right corner of my house is where the wood stove is. So not handy. It's where the fire would be. And I think something that a lot of people don't realize is the privacy that they can gain by naming specific beneficiaries and not having all the information about their assets published. So that's one thing I'd love for you to elaborate a little bit on. And the other thing is naming minor beneficiaries. I saw a case this year where a couple were not married. The man passed away unexpectedly. The mother was already caring for the children, but the dad stole all the money.
Right.
The dad of the deceased.
Right. Right.
Grandfather took the money for himself.
Right.
His financial advisor was in on it. It was a very, and it's still going on. It's been over a year, 3 years.
Yeah. So let me start with the first question. I strongly believe that on every bank account, every life insurance, every investment account, every especially safe deposit boxes, that there be named beneficiaries. And those are the people you intend to get the contents and the value out of. So, and I also like things to be owned jointly. Especially as you enter your 70s and 80s, you should have your property, all property, hopefully with another name on it with you, either joint or as a life estate or in some other way, they'd be on there. And on vehicles, believe it or not, vehicles and camper trailers, all those things have to be transferred title. It's quite a few steps. If in your later years you add people's names to things, they automatically own them when you pass away. I also believe in gifting things that you're not using anymore. So again, to the extent you have lots of stuff around and you haven't touched it, or you have your spouse's stuff who's passed away and you just haven't been able to bring yourself to give it away, I would remind you that you're just passing the buck, that you do need to get things organized and taken care of. I love my mother-in-law. She cleaned out her house when she turned 80. She did her whole basement. There is nothing left down there. And she gave it all to people who needed it. And none of us needed it. And it's done. None of us have to go down in her basement ever again to clean things out. It's beautiful. And I thought, I am not like that. I need to do this. And so I'm looking at that. Now, minor children is very difficult. On minors, and this would include minor grandchildren or other minors that you're unrelated to that you wish to leave things to. I recommend that within the will that there be a trust created. It's called, again, it doesn't start until you pass away. So the trust is part of the will, and it creates a trustee who will take the belongings of the minor and keep them until they reach whatever ages you want them to see it. And they could see it at 18. I don't recommend that. I like 25. And if it's a lot, I like it staggered so that they get 3 disbursements over time. The reason why is because a lot of young people do not know how to handle money. I use my brother as an example. He inherited some money and he got it all at 21 years old. And it was a significant amount of money. He spent it all by the time he was 23. It was gone. And that was ridiculous. The only part that remained was the real estate that was in his name. And luckily that was locked down in a way with an extra person on the deed, so he could never sell it without the other person's name. Me. And so I held on to his until he turned 45. And when he was 45, he finally, had a family, a home and things. He wanted to sell property. Now I'd sign off for him. Now that was kind of again, the way to do that. But I love inter vivos trust for children. I think it's highly dangerous to leave it in a situation, especially with divorced parents, because the natural parent, the one that survives, does become the natural guardian of minor children and therefore is entirely in charge of their assets unless you set it up otherwise. And so divorced parents really have special needs and should really come and see probate lawyers and get that will in place, especially if there are enough contention going on that they've already litigated through the divorce. They're going to litigate through an estate. You can kind of bet on it. And those robberies occur more often than we would like to acknowledge. I think that's a really good point.
Martha, I like what you said about staggering distributions through the trust as well, because I have talked to so many people who inherited money, they blew it all, and they don't get another chance. So in fact, if you can do a smallish distribution first, it gives them a chance to blow it and learn and get another chance. I actually really, really love that. And I'm going to start suggesting it for my clients.
Well, it's really a good idea. And you're right, a small amount first. $5,000 is a lot of money to somebody who doesn't have any money. And a kid coming out of college, $5,000 is a used car. That's good. You give them $50,000, and the case I'm talking about went and bought a van that was carpeted on the inside, looked like a love bug. And then it dies in 5 years, and it's an expensive, ridiculous thing. So again, pacing that situation works. Then there's going to be people, and let me just touch on this as well, maybe a son, daughter, or a sister that you want to leave because they are special needs. There are things, again, like there are minors trusts, there are special needs trusts that can be created within a will, so that let's say you had a brother or sister-in-law that needed additional, and you were sending them money on a regular basis anyway, that you might put a home or a small amount or a large amount of money for their long-term care after you're gone. You might put a life insurance policy. I notice we have some people here who sell different products. There are different things you can set up for those people that is not reachable by creditors in a special needs trust. And we can also create for them a lifetime of income that is sheltered as well, so that they can continue to receive public benefits, housing, medication, main care, other things, food stamps even, and yet have this in the background for their financial security. Those special cases should be addressed earlier as opposed to later. And I tell people, if you wait too long, then we could have all kinds of too many voices telling people what to do for that special person. And you know what you want to do. So you pick, you decide, and we set it up your way. And that way it's guaranteed to be there for that person. Unlike, like you were mentioning, Rory, someone who wants to rig the game and get a hold of their disabled sister's funds. I've seen that occur. And that's absolutely tragic when it happens. But I'm unfortunately seeing the bad side of life, right? Sitting on the other side of this desk. After 35 years, I can tell you money changes everything. I've seen people who had never, their parents wouldn't believe that they would do this, actually go to blood fights over, not even a large amount of money, or not even a large home, but just because they believe they're entitled. And that once that locks in, and sometimes it's a little bird in their ear, a spouse or somebody else telling them what to do, it doesn't matter. At that point, it gets so ugly that I cannot tell you how it splinters family in the worst ways. So do try your hardest to think about how to keep the peace and how to do it the way you want, and do it sooner than later.
Martha, I have one final thing that I want to mention if you still have the time. Something that I see.
I gotta go, guys.
Oh,
Thank
Bye,
you,
Nettie.
Martha.
thanks, Nettie. I hosted an event about intergenerational wealth planning, and one of the attendees talked about how there was property left behind when her parents passed away. And the 3 siblings were meant to split it, but one of them was living in it. And they each had sort of different emotional relationships with money. So they, in fact, ended up nearly giving the property away because none of them wanted to look like they were looking to benefit from a windfall from something so tragic and terrible happening as the loss of a parent. That it's so helpful as the person who's exiting the world to be able to say what you want to happen, if that's sell it for whatever you want, if you want to be done with it, or get as much money as you can if you want, and don't feel bad about any of it. And like, maybe there's no way to actually convey what you really want.
Sometimes it's good to have a provision in there that if anyone waives their inheritance, I would like my donations to go to, again, a charity, a church, or a school. I've seen those, especially with families where all of the offspring have good jobs and already own everything they ever needed. And there is a little bit of hesitancy, especially if it was a tragic end, to take their inheritance. So there is a mechanism by which people can waive inheritance, and then there should be a clause, I call it a saving clause, that throws the inheritance to wherever the person who passed away would have put it, had that person not been alive at the time of death. So those are really good thoughts. And again, sometimes I think everybody should have that saving clause in there that says, and if no one is here and no one takes, this is where I want it to go. And that is, that's how, again, the Red Cross gets their money. That's how the Humane Societies get a lot of their funds, churches as well. And it's traditional, again, to split off to some of these because the government cannot pay for everything, nor should they. And so I think it's a good step to keep in mind. Absolutely good, Lori. Thank you for that.
I want to be respectful of your time as well, Martha. It's a little after 1. And excuse me, but I know we could talk about this for hours. You'll definitely be
you.
hearing from me. This
Thank
is
you.
something I've been very passionate about the last couple of years. I lost my parents. Thankfully, I say thankfully, they didn't have a will. They didn't have any of this stuff in place, other than written on paper underneath a calendar that my mom had. I was
Yeah.
just fortunate that I didn't have siblings that wanted to fight over things. We did it very
Yeah.
peacefully, amiable, but I know that's more uncommon than common.
It really is.
And
Yeah.
we really appreciate your time today. I do want to end. I found a quote that I thought was just extremely fitting for our conversation and our topic today before we go. Hope everybody has a great week, and we will see you next week. And I close this with, it's better to look ahead and prepare than to look back and regret.
Oh, that's beautiful. Thank you all.
you. Bye-bye,
Thank you.
everyone.
Great day, everybody.
Yeah.
Thank you, Martha.
Thank you, Robin, for inviting